Fantastic. So just obviously to introduce us, my name is Julie Ford. I run Hemel and Landlord Property Network, and obviously I've got my co-host Paul Shamplina of Landlord Action, and we'll be talking about the new pre-action process that has been released for landlords. So hopefully my screen will change. Or not. Sorry, it's all getting a bit technical this morning. Let me see if I can change my share. Okay. So just a little bit of housekeeping first of all, just to let everyone know this event is being recorded. Please keep yourselves muted. Any questions, please put them in the chat box. And just to say, we've got no planned fire alarms this morning, so should your fire alarm go off, please make sure that you leave by your nearest exit. And just to let you know that us as hosts can't provide you with individual advice, you'd need to contact us separately for that. So I'm just going to move in quickly to basically what this is all about. So it's all about the new civil procedure rules that have been introduced through COVID. Now, we all know that the Coronavirus Act came into force in March, and that changed a lot of things with regards to notice periods. And then shortly after, all the courts were suspended and they weren't working either. So basically, civil procedure rules are a set of rules, procedures that the courts need to make sure landlords and anybody else has abided by to ensure that an eviction or a possession order or anything else that's under civil, so not a criminal case, has been done correctly and all the boxes have been ticked. So that's basically what a civil procedure rule is. So moving on to what has happened in the last few days. So we've had this amendment number 4, which is the Civil Procedure Amendment to the Coronavirus Act, and it inserts a practice direction 55C. Now, I'm also going to talk about later on amendment number 3, but I'm just going to cover that very, very briefly. And the key dates that we're looking at throughout this presentation is obviously these new rules come into force on the 23rd of August 2020. They have an end date because they're only temporary legislation of the 28th of March 2021, and there are review clauses within this, so the government could change their mind up until the 20th of March. It affects all claims put into court before the 3rd of August. If your claim has been put in after the 3rd of August, it will be dealt with differently. And there is a key date of 4 p.m. on the 29th of January 2021, which we will cover in more detail. So what I'm going to do is I just hand over to Paul for the next couple of slides, if that's okay with you, Paul. And then we'll just go through the fact that these are temporary legislation. We know that it doesn't affect the mandatory grounds. So section 21 and section 8, grounds 1 to 8, we know that they can still be used, albeit with 3 months notice, but what it is they won't affect the fact that landlords can still rely on those mandatory grounds. So can I pass over to you, Paul, for the key points?
Yes, of course. So with regard to, actually, there is a real key date that's going to happen. Hello, everyone, by the way. Nice to be here with you, Julie. I think there's a key meeting that's happening today, actually. I have been speaking to Ben Beadle, who is on the judicial panel that's dealing with this, and there is going to be a further announcement. It's been chopping and changing, and it's been quite unclear. We've been obviously breaking stories, as you know, Julie, on Landlord Zone. And there was talk that a lot of the tenant groups wanted a lot of the grounds to be switched to discretionary during this pandemic. It's really, really tough for landlords. And as I keep saying, before I talk about this reactivation notice, Landlord Action, the company that I started 20 years ago, we have 10 solicitors and paralegals, and we might do the best part of 1,300 to 1,500 cases a year. Okay, we're a regulated firm of solicitors. We've got 500 to 550 cases stuck in the court system, all pre-COVID. Okay, and they are the landlords that have been affected the worst by this pandemic. Be very, very clear about that. I'll give you one example of what we're going to be doing at Landlord Action. I've literally got a press release, which I think is going to go out next week now. It's a landlord hardship stories, which is basically talking about landlords that we currently act for, and talking about their personal situations because of the delays, because of obviously the pandemic. So they had rent arrears that accrued prior to COVID-19 coming in, and obviously the lockdown in March and so forth. And we've got landlords that we anticipate will have rent arrears of over a year, without a doubt. We had one landlord, she was actually going to feature on the TV programme, and obviously I was lucky enough, all the filming stopped. I finished all the filming prior to COVID-19, and just for the viewers on this network, the new series comes out on the 11th of August at the moment, so we know, and that's going to be at 9 o'clock, and that's the 6th series. But she had £22,000 rent arrears, and you know, she didn't use a letting agent, made all the classic mistakes, Julie. And 2 days before the eviction, she was going to film with us, she gets a letter from the court. It was early April, basically saying that her case had been suspended. So that was in April, she was supposed to get a property back. We go 4 months later to August. What's going to happen is you're going to wait for the courts to open up, and then she's in a queue. Now, she's at Central London County Court, the busiest court in the country. There might be 3 or 4 bailiffs, 5 bailiffs in that court. I mean, it's so backed up. So then she's got to wait for a date to be released. So she could be another 6-7 months in arrears on top of the 22 grand that's owed. It's crippling for landlords. And people aren't getting that. They're not understanding. And of course, as you know, as you said, the new rules came in with regard to the 3-month period. We know as of yesterday, and it's in Landlord Zone. Please go on the Landlord Zone website. Wales have just announced that notice periods are 6 months, and don't be surprised if we follow suit. It is crippling for landlords. Yes, of course, you've got to work with your tenants and you've got to mediate your tenants and work with them. But it's actually worse for the landlords that have got rent arrears pre-COVID-19 that had nothing to do with their own situation. And of course, you know, once lockdown happened, the first month I get 5 to 10 landlords a day contact me, and I know you do, obviously, and you do a lot of good work, Julie, going on various different networks, but I get contacted by landlords and tenants and trying to work with them. And that's why we started the mediation business for the property redress scheme, to try and mediate. And half the cases that we've done in mediation, we've actually settled, so they've avoided going to court. And now when we're speaking to landlords, and I've told all my staff at Landlord Action, you have to have blunt conversations with landlords. And we're trying to manage their expectations. It's so difficult, because you've got a landlord, and 90% of landlords have got 1 property, 2 properties. They don't see themselves as landlord. They're relying desperately on that income. They've got mortgages to pay, but obviously the saving grace, of course, is the mortgage rate is 0. So you know the mortgage, the interest rates aren't that high. So there's a whole lot of stuff going on. But with regard to the reactivation notice, as you can see from the slides, you've got to for the cases that are currently in court, you basically have to tell the courts that you want to carry on with the cases. And the reason they've done that is because there might be loads of cases in the system, and actually the tenants might have left, or there might have been an issue where it's been settled, and they want to pull all those cases out of the system so they know which cases need further hearings down the line. Okay, and of course with the reactivation notice, what is important is you've got to set out, and this is an issue that I have, and supposedly we've had mixed messages on this, Julie, because Chris Pincher, the MP, basically said in Parliament, you have to, as a landlord, find out about the defendant's current financial situation, their benefit situation, employment details, how has COVID-19 affected them, okay, and obviously provide a rent schedule for the previous 2 years. My argument, and I literally had done a quote last night for Landlord Zone, okay, and this is where it's confusing, is Chris Pincher basically said in Parliament yesterday, if a landlord cannot get doesn't provide the information, a case can be adjourned. And that can be fatal for a landlord. They've been waiting 6 months for a hearing date, and because the tenant doesn't engage, and bearing in mind, when we go to court, relationships are broken down. You've tried to mediate, you've tried to speak to tenants. Tenants don't want to speak to landlords. They owe them £5,000-10,000. The last person I want to speak to is a landlord. And a lot of tenants, and every case is different, you know, and a good tenant doesn't turn into a bad tenant overnight. And obviously, you know, rent arrears are accrued and everyone's circumstances are different. And of course, at the moment we have furloughing, which is 9 million people. Once that stops, then you will get a true reflection of unemployment, and obviously that will go up. But to penalise a landlord because a tenant doesn't come back to you, bearing in mind the case is already in court, tenants won't respond. A lot of tenants will just want to wait until the day before the eviction and leave the property. And 80–90% of the time, the landlord never, ever, ever gets the money back because they can't collect it. So I put that point to Ben, and Ben and Charles Peaker from Nearly Legal basically said, no, that's not correct. There is a tick box exercise to say that you've tried to engage, but I'm getting mixed messages. And I've even, I don't know, Nigel Lewis, our editor at Landlord Zone, made contact with the Housing and Communities Department, and they said this. So I'm a bit confused, to be honest. You know.
Yeah, I totally agree. I mean, it's interesting as well seeing different news reports on this, because again, we're, like you say, we're seeing contradicting information. And I think the issue is it's open to interpretation. I mean, I've been speaking to Giles myself directly, and again, he's saying that some of it seems a bit overzealous, some of it is worth doing. But for me, with the rent arrears clause, if you're using your notice because of rent arrears, you've got to provide previous 2 years worth of accounts. Yeah. I mean, obviously, if a tenant hasn't been in your property for 2 years, you can't provide that, that's fine. But how many landlords realistically are keeping such up-to-date documents, especially landlords with maybe only one property? That information may not actually be available.
I totally agree with it. I mean, this is, look, the reality of these new steps, and I understand these new steps, and I'm sure we're going to come on to the steps with regard to hearings. I mean, I've seen part of the scheduling that's been set down and so forth, and I think there's going to be further announcements after today's meeting from what Ben has told me at the National Residential Landlords Association. You're quite right. I mean, the reality, and I tell it how the reality is, because I've been doing this, you know, and you know, I issued my first possession claim in the early 90s, 91, 92. I used to work in solicitors, and then obviously I became a landlord after I set up Landlord Action. The reality is, when you're on the ground, and you're on the ground as well, because you speak to landlords on networking groups and whatever, the reality is there is a much more burden on the landlords. Now, at Landlord Action, we'll be sending 550 letters out to the courts for the reactivation. We know how to do it. You know, that's why that's the advantage of using a regulated firm of solicitors that do this day in, day out. But you've got the landlords that have issued claims themselves. And you know, Julie, it's more difficult now to issue claims than ever before. When we come out of this, the claim forms are going to change. You've got to do pre-action protocol. It's harder than ever. And one little mistake and you get it wrong, case dismissed. And these hearings, and as you know, and I've even say, you know, and we haven't even talked about the possible banning of Section 21 and housing courts, you know, because you need major investment in the housing courts. This is going to be a major test to the courts, and there is going to be backlogs. There's no two ways about that, you know, and trying to, I mean, we literally have on Landlord Action, we call ourselves Landlord Samaritans, Julie, okay? Because, you know, landlords get a disease called landlord rage, right? You know, the tenants in there, you can't go round there, you can't knock on the door, you know, and of course, you know, with COVID-19, you've seen more empathy, sympathy, and engagement more than ever. And landlords have done some amazing, great things. And as you know, I've campaigned vigorously for landlords over years. And I get frustrated with the rhetoric, you know, greedy landlord this, greedy landlord that, you know. And, you know, but I also took calls from tenants on how unreasonable some landlords were, you know. And I actually spoke to a few landlords on tenants' behalf. I do that, like, I get a message all the time, you know. And I think that was wrong. So it's conflicting. What's the next slide? Is it about hearings, about the spacing out of hearings? Have you come to
let me just have a look. So I just want to make sure that we've covered all the facts as we move through. Obviously the key points are that it's all the possession hearing dates that were prior to the 27th of March obviously have been stayed. So stayed means that they've been suspended. The reactivation notice will need to be filed to the court and served on the tenant, together with the required additional information. They say no later than 42 days before the hearing date.
But on
So
that point, Julie, I mean,
yeah,
on that point, and that's a very important point, right? I can tell you now, when you do a hearing, we issue possession claims online on PCOL. So during all of this, we've been issuing claims at court in Section 8, Section 20. We've still been issuing claims. You can still issue claims in the court system, get your case number, put it in the queue. That's very interesting because basically they're saying to you, you're not going to get a hearing date for at least 42 days. So expect that on that day after you get some sort of correspondence from the court. The quickest hearing date we've ever had at Landlord Action was, I think, 29 or 30 days at Southend County Court, and that was in a possession claim. So I think that that's an indicator of extra time you're waiting. But of course, if you've been in the court, and this is important, this is what the NRLA have been campaigning for, especially antisocial tenants, okay? They should be dealt with separately. I don't know if they are, or cases that have been in the system, the oldest, they need to be dealt with first. And I don't know how that's going to be. And of course, every court is going to be different because, of course, in city courts, there's much more buy-to-let and it's much more busy. I mean, we have something like, we might do 30 hearings a month, and in one court, we might have 5 or 6 hearings, you know. And of course, the biggest challenge in all of this, and I can tell you this for a fact from being on the housing consultation and going up to Leeds and on the working group, is they are struggling to recruit judges. And that was pre-COVID-19. So, you know, we need to see, and I'm not trying to scaremonger people, but it's a reality of the 3 months. And then, of course, these 3-month notices are now starting to run out. Okay. So then they're going to be kicking in, and they're going to be COVID-related cases.
Yeah.
You know. So
absolutely, I totally agree. And obviously, like you say, with the notices running out, people also need to be mindful that if you'd served an ordinary 2-month notice in January or February before these restrictions came in, your Section 21 only has a 6-month shelf life.
Yeah.
So people need to understand that they need to get their claims into the court, even if it's to just sit there in limbo, just to make sure they don't lose that 6-month shelf life on the Section 21s.
That's right, use it or lose it. Actually, that law was actually my idea when I was working on the Deregulation Act. And I also brought the idea of serving a notice out after 4 months. That was my idea. And I got, I'm going off a little tangent there. I got loads of grief. I was standing up at a conference. And you remember, you'll know, Julie, do you remember when you used to serve notices right at the beginning of the tenancy to end it, which was terrible practice and really lazy because, you know, your tenant is your customer, brand new tenant, you've come in, you give them a 12-month tenancy agreement, they sign the tenancy, and then they say, oh, by the way, there's a Section 21. And we had a case at Landlord Action that got dismissed because it was served on the same day. And the judge says, what comes first, tenancy or Section 21? And obviously, you know, we had cases where you were issuing possession proceedings when the notices were 4 years old. So they were quite good ideas. But there was one letting agent that had a right go at me once. I was standing up at a conference with about 200 letting agents. And she said, oh, it was your fault then, right? Yeah, your fault, we have to serve it. And I said, well, hold on a second, you found a new customer. That new customer, actually, you want to get a renewal. And why would you want to tell them you want to leave on the first day? It's just terrible practice. So they got rid of it as well.
No, absolutely. So obviously, like we said, you've got this 42-day notice period. So that means that anyone who's got a hearing listed after the 23rd of August really should be getting all of their ducks in order now to ensure that they don't lose that hearing date. And the other point in there is obviously the 4 p.m. on the 29th of January, which is all parties that fail to serve a reactivation notice on any claims issued before the 3rd of August will find that this will be stayed forever. So the courts won't reactivate it automatically, and landlords or tenants, because tenants can also serve a reactivation notice, remember, this isn't just all on landlords. A normal application to lift the stay will then obviously be required. So I'm just going to move on now, if my slides, to the claims prior to the 3rd of August. So I've split them up, prior to the 3rd and then after the 3rd. So like I said, what is a claim? So the claim is the process of actually putting in the application into the court, your physical document into the court, not the actual notice served on the tenant. I've had a few landlords a bit confused about what their claim is. They believe that their claim was the Section 21 or the Section 8, not the actual application put into court. So it's applications sent to the court prior to the 3rd where no possession orders had already been made. Those have obviously been suspended. You'll need to serve a reactivation notice. The claims will not automatically be started by the court on the 24th when they reopen. Failure to submit, as we've already said, means that the case will not go forward. So it's really key to remember those points. We've already talked about the reactivation notice, but what we need to understand is what needs to be in it. So we know it doesn't need to be in a prescribed form, so that's really important. We're not looking at something like the Section 21s have to be a Form 6A. This can be a letter, but it must be sent to the defendant, the tenant, and it must be sent to the court. It also affects accelerated possession claims. So it's not required if the possessional order was previously granted that was stayed. So if you've already got a possession order, you don't need to do a reactivation notice. But if you've just put the claim in and nothing's happened yet, then you need your reactivation notice. And your reactivation notice must contain the following: the request to the court to either list it, relist it, have it heard or referred. If you don't do that, the court won't know what you want to happen with your claim. Set out what knowledge you have of your client or your tenant's position that the coronavirus has had, what effect it's had on them, such as have they claimed benefits, their employment status, have they been furloughed. Where a reactivation notice is served by the claimant, which is the landlord, and the claim is based on rent arrears, as we spoke about earlier, the landlord must provide an up-to-date rent account for the previous 2 years. Now, if your tenant hasn't been in the property for 2 years, obviously you can't do that, but it must be accurate records from the start of the tenancy if it's less than 2 years. However, this doesn't affect the claims that are going forward that are actually appeals. And where this information isn't provided, as Paul has already said, the jury's out at the moment, but judges have the ability to basically not take the case and adjourn it. So claims after the 3rd of August. So after the 3rd of August, if you're putting your paperwork into the court, you won't need a reactivation notice because the courts will know what you want to do. The landlord will need to bring to the hearing 2 copies setting out the knowledge they have of the defendant. So same with the reactivation notice that asks, what do you know about your tenant, their situation, how has Corona affected them? You need to bring 2 of those copies to the hearing. You need to serve these documents on your tenant not less than 14 days prior to the hearing date. So you've already got the fact that you've got 42 days from the hearing date from the court, and now you've got these 14 days prior to the hearing that with the document explaining everything must be served on your tenant. And again, this does apply to accelerated possession cases. A copy
on that point, Julie,
yeah,
which is quite relevant, you can see that the point of the reactivation notice and the point of engaging, speaking to tenant, finding the situation, seeing if it's COVID related. Obviously, I think landlords will have more success with this because obviously the claims are fresher, and actually you've served notice and you've tried to serve notice and you know a bit more because it is COVID related. As I said, the previous trying to get the previous information when the relationship is broken down is going to be really, really difficult. But the whole mindset of what the government has, and it comes back to the mediation and engagement, is making sure that you have been speaking to your tenant, and has there been a way of working it out? You know, of course, you know, there was various different circumstances. Landlord needs to move back in, needs to sell, and all that type of stuff. Yeah. But I think that is partly the meaning as to why this is happening, as well as to try and whittle down some of the ongoing cases which might have finished, but obviously you haven't liaised with the court. So yeah, I think landlords. And knowing what landlords are like, especially the self-managed landlords, the ones that try and do it themselves, they're going to be the ones that really struggle with this because they won't know what they're doing.
Yeah, I absolutely agree. And like I say, it also applies to the accelerated possession process. And landlords must serve the document, obviously understanding their tenant situation, with their claim form, not after. It must be with the claim form. So that's a key point there. The notice from the court. So courts are also going to be changing the way that they do things. So the courts will give a minimum of 21 days notice to both the landlord and the tenant in respect of a listed or relisted hearing. The normal rule, which is 8 weeks between issue of claim and hearing, has been disapplied. So basically we're not looking at that time frame anymore. And this basically is going to indicate that we're going to expect significant delays. We already spoke about earlier on the previous slide 42 days notice, so we already know we're looking at 42 days. It's probably going to be an awful lot longer than that. I've spoken to a lot of landlords, and I've been realistic, and I've said, if you're serving notice sort of now, you're not going to get an eviction before 2021. It's not going to happen. It's going to be next year.
Correct.
The eviction warrant. So there's obviously been a change to this as well, which I found quite interesting. So this is where we're just going to talk quickly about the Civil Procedure Amendment number 3. There was obviously 4 amendments, but this just applies to eviction warrant. It includes possessions of to transfer the possession to the High Court. So I know a lot of landlords try and do this to speed up the process, and it also includes High Court sheriffs. So the notice of eviction must be delivered to the premises not less than 14 days before the warrant is due to be executed. So normally,
currently with High Court, sorry Julie, and currently with High Court evictions, it's 7 days.
Yeah.
And they changed that process the last couple of years, purely because obviously you saw programs on TV, not obviously my program, but the other program, where they would turn up without giving the tenant any notification, which was really bad practice. So normally you'd have to go to court. We have someone in our, obviously when the courts are open, that would go to the High Court twice a week and go before the master, because we'd had leave on the court order. But people say, oh, I want a High Court bailiff, I want a High Court bailiff. You know, generally maybe 2 out of 10 judges would give that. We plead it on the procedure, you know, on the proceedings under Section 42, and show landlord hardship. But, you know, most judges will not let you have leave to transfer up to the High Court, because they see, oh, you're taking income from the court. You know, you're losing the warrant fee as well.
Absolutely.
But it can be frustrating.
Absolutely. So this amendment to the rules will mean that your tenant will get 14 days notice of the pending eviction. And the notice will have to include to the tenant information of how they can suspend that eviction warrant. So normally they would only get that information if they went for assistance somewhere like Citizens Advice, for example, and then the tenant would be advised that they can submit an N244 or something like that and get these evictions suspended. But this information will now have to be within the eviction notice. So your tenants will be a lot more informed moving forward. The eviction notice also must be addressed to everybody in the property, so that's the tenants and anybody else that occupies the property. Be in a prescribed form as set out in Practice Directive 83. Now, you don't really need to know what that form looks like, because obviously it will be the courts that issue those rather than yourselves. And the eviction, this is the key point for me, and I've highlighted the word transparent because I've never seen a transparent envelope in my life. The notice of eviction must be delivered by inserting it through the letterbox in a sealed, transparent envelope.
So it's basically like it's an A4 plastic folder. Is basically, it's like,
yeah, that's what I was thinking. One of those ones that go in the binders.
Yeah, it's ones that go in the binder. It's exactly the same we use. So we at Landlord Action, we issue squatters cases, persons unknown, and we put them in those when we have to address it to persons unknown, when we have to serve it and stick it to the door and all that stuff. So it's transparent, and so that needs to be done. I mean, obviously proving how you've done that. What I can say is, you know, it says here the notice of eviction must be delivered inserting it through. So the onus obviously is on the landlord, not the court, to serve this. Okay. And what I can do, and obviously I used to be a former process server, hand delivering stuff many moons ago, is when you are serving this and when you have to do this going forward, make sure just before, I know we do this with all our notices, we have process servers up and down the country, it's just before you put it in the letterbox, take a picture with a newspaper and just take a few pictures just to prove it. The great thing is now camera phones are amazing because you've got that proof. Obviously, back in the day, you'd have tenants that would deny that you've received it, and then they would try and use that as an excuse to obviously try and defend the case and suspend it and make an application.
Yeah, absolutely. So like I said, it needs to be in this transparent envelope. So like you say, an A4 pocket wallet will do. If you can't put it through the letterbox, then you need to start installing stakes around the property and attach it to stakes.
Is that annoying stake? What type of stake are we talking about?
It just says placing stakes in the land to place the clearly visible document and obviously
Not
attaching
a
it.
sirloin steak, no.
No, not a sirloin steak, sadly.
Okay.
Mind
Okay.
you, you
All
could
right.
probably do it with a T-bone.
Okay, I just needed to clarify, just so the audience knows.
So that's brought our slides to an end. So what I'll do is I will stop sharing, and then we'll go to the chat box, and then go through any questions that anybody has got. I have seen one question come up in the chat box, so I'll just see what that is.
I think it was from Zoe, my good friend Zoe in Bedford, Belvoir. Hi Zoe, hope you're well.
Yeah,
the
that's
reactivation,
right.
the reactivation notice is not a prescribed format, as what Julia mentioned. It's basically a letter detailing what's in it, how to get it, and obviously it's going to have in the reactivation letter, it will have the additional information.
Yeah, I mean, I have drafted a reactivation notice copy, but the problem is they are going to be so individual to the client's situation, whether you're having it listed, relisted, heard, referred, obviously your tenant situations, but you know, it's going to be individual to you, and it's just thankful that hasn't got to be in prescribed form. It can just be a letter that is then given to the
Can you
tenant.
imagine doing 550 reactivation letters?
I don't envy letting agents at this particular
Well,
point.
no,
I
I'm
must
talking about
say.
landlord action.
Oh, you've
I
got
mean,
people for that. You've got people.
I know we've got people, but we're not going to charge them whatever, because it's just the hardship and the stress landlords are going through. It's tough. It's getting the fine balance, and that's what the government have tried to do. It's trying to get the fine balance, and it's really just trying to get people to understand the reality and the hardship landlords are going through, because we know more than ever, and that's why I write about. That's why I do the TV program. I show the other side, because not every landlord is a millionaire. Okay, whatever the tenant groups say, all right, just because they own a property, and a lot of it has been luck and it's been accidental and all that, and as you well know, majority, there's far more bad tenants than there are rogue landlords, without a doubt. Okay. I remember saying that at a conference one, and I got shot down by a lady from the tenant group. She took offence to that, and I'll give you stats if you want. I put my mortgage on it, but that's a reality, and we don't, and I think that because of what has happened, it's still not a true reflection as to what's happened. Yeah, you might have had people laid off. I mean, during lockdown, there's 1.2 million people claimed universal credit. It's now up to 3.7 million. Okay. And of course, universal credit is a massive problem in itself, which we haven't got time to speak about. So it's just, there's more and more hurdles for landlords. I understand why they've been put in place. They don't want to rush of home. We have a homeless, there's been a massive initiative with regard to homeless funding, and you'll see that they brought a lot of homeless people on the street. And only a couple of days ago, I spoke to the Ministry of Justice. I'm doing some advisory work with them for ex-offenders that they want to try and rehouse in the private rental sector. So I'm trying to come up with a package to try and help in how to sell it to landlords. So I think that generically, I think that there will be a massive surge in social housing. I called that quite early on. I think because of everything that's happening, furloughing, it's all got to be paid back. That's the reality. So we're not going to have a true reflection really until the end of the year, when they do stop the furloughing, of seeing what tenants' circumstances. I think that it creates opportunity, and I see a lot of tenants that may lose their jobs, as well as landlords as well, because landlords' businesses have stopped overnight and this, that, whatever. I think you'll see, there'll be opportunity to find work and reinvent yourself in different careers and stuff. But the true reality of the economy won't kick in until the end of the year.
Yeah, no, I agree with you, absolutely. Has anybody got any questions regarding the presentation and obviously these new rules moving forward? Anything that we probably didn't explain very well, or just got questions of how it's going to happen? Oh, everyone's very quiet.
There's two. It says there's two down there, or not?
No, that was Zoe just saying.
I want a question from Sean Hooker, my work colleague. He's always got something to say for himself. Come on, Sean, give me a question. Give me and Julie a question. It's gone quiet, which is not like him.
No, maybe he's not actually listening.
Well, yeah, I don't know. It says that he's here, but yeah, maybe he's not here.
Okay, Nick, anything from you? I know we were having a discussion about this yesterday. No. Wow. Oh,
It's been as they say, it's been a cheap round.
oh, it's all right. They're all coming in the chat box now. Look, no one wants to talk to us. We must be scary.
They're all shy. They're all a bit shy, aren't they?
Right, let's just have a look. Okay, so from Nick, this means that we would have to get landlord action to do an eviction, as it's too complicated, and yeah, it's too complicated now.
Hi Nick. I've known Nick for years and years. Nick's an old landlord action customer. Yeah, it is. I mean, look, even if you don't use landlord action, just use a regulated firm of solicitors. You know, it makes sense. It's so hard to keep up to speed with what's going on. There are eviction companies out there, but they're not regulated. I would just say, just use a specialist. Look, you know, most landlords will never ever have to evict a tenant, or or most landlords might have to serve a notice, but the tenant leaves. Or try and do a deal with your tenant. You can't, and mediate, or try and mediate yourselves, or maybe if we can assist mediation, try and do a deal, knowing that you're in for another 6 to 9 months. Do a deal if you can.
No, absolutely, buddy. First of all, good morning, guys. So if you can hear me, I'm not sure. But more importantly, we can't afford to get it wrong. Because if you get it wrong, you've got like a 6-month wait. And you've got another 6 months after that to get it right. So it could be another year plus. But so we just cannot afford to get this thing wrong.
Listen, one bad tenant, Nick, can really affect your portfolio, and you can you can lose money. Bearing in mind the news yesterday, again, you need to keep your eye on it, folks, because England does follow suit with Scotland and Wales, and there is going to be eventually landlord licensing and landlord redress. It's all going to come in. That's a given. But bearing in mind now, Wales have now said you to serve a notice. It's a 6-month period. Can you imagine? You're serving a notice. There's 2 months rent arrears owing anyway, and then you're decided, I need to take action. You've got to serve a 6-month notice. So then they stop paying the rent for 6 months. Then that's 8 months, right? This is a landlord, if you will. Then you're going to issue proceedings. You don't know how long the proceedings are. You're in for another 2 months to just get a hearing date. Then you get your 14-day court order if you're lucky. Then you get your bailiff eviction, right? 6, 8. You could be looking at 14 months rent arrears.
Yeah.
That's a reality. It really is. And people, and yes, there's a fine line, and you don't want, that's why, obviously, tenants need greater support when there is rent arrears. Yes, there's benefits, and that's why, you can't have, have to have direct payments on universal credit, which is absolute madness. I mean, landlords can't afford 14 months losses of not having rent. They've got mortgages to pay, and that's why there needs to be much more initiatives. And I'll certainly be raising that with governments and people I speak to, because it's reality.
And Paul, that's the best case scenario. That's not even the worst case scenario.
And your tenant defends the case. The tenant defends the case, and it's really, really worrying for landlords. Yes, there is procedures, whatever, but for landlords, if you've got and of course every tenant, every circumstance is different. Every case is different. You might be, a couple might have broken up, or guy might have left. The problem you've got now is reality. What's going to happen? You're going to have landlords that are going to be really, really more stringent with referencing. Bearing in mind, we haven't talked about Section 21 going, which is going to go, I reckon, in 18 months, right? So that's in the background. I haven't rushed that through. So I mean, there is it's a worry. It's a worry if you have a bad tenant and they're not paying the rent, of how you deal with it, how you cope. And you just see my TV show of landlords getting landlord rage and losing it, and they're small landlords, and that's why yes, ideally you want to get a rent guarantee policy in place, and of course that market's changed because some of the insurance providers haven't paid out. But I mean those policies are going to be much more expensive now. And that's why as a landlord, I always say use a letting agent, because if you use a letting agent, there's a good chance that the tenant's going to be referenced better. They're going to be pre-qualified. But I think that you'll see a lot of landlords, maybe like yourself, Nick, or portfolio landlords, that will actually think, you know what?
Yeah.
I'm worried about voids. I'm worried about everything that's happening, legislation, this, that, whatever. I'm going to do direct deals with the council. You'll see more landlords doing 3 and 5 year leases with councils now. I think that's inevitable.
Yeah, I mean, I totally agree with that. There was in one of the industry magazines this morning, I saw that I think it's West Lothian Council are actually reaching out to local landlords and saying, look, we're here, we want to work with you. And they are looking at 3 to 5 year leases, guaranteed rent, financial incentives. And I think that's just going to roll out along throughout the country.
It will do. It will do.
There isn't enough social housing available.
Cool. I mean, I mean, there will. Yeah. I mean, it will happen. You'll see a lot of guaranteed rent scheme. I mean, that market, the guaranteed rent market, has been slaughtered as well, because you've seen small little people doing rent to rent. A lot of them don't, unfortunately, know what they're doing. Really good companies that do it right, like Northwoods, who are great, and they've got obviously capital behind them. You know, but the hardest hit markets have been the student market, without a doubt, and obviously HMO market. So yeah, I mean, you know, as a landlord, you've got to diversify. You've got to change up. I mean, you've got to change up your portfolio. And of course, you know, you look at the Airbnb and the holiday let market. That's been battered. You know, 90% down. And I know in Edinburgh, where there's a big Airbnb economy, and of course there's been empty properties, they've been reaching out to landlords to do these lease deals. I think it's a good opportunity for councils to try and engage with landlords, and landlords thinking, you know what, I will do a deal. I don't want voids, as long as they make sure the property's put back into a reasonable state, and I'm going to get X amount for 3 to 5 years. Because you're also going to have scenarios where tenants won't be able to move because they've come off furlough and they've lost their job, you know, and then they won't go through referencing. They can't get through referencing. There's a whole load of stuff that's going to unravel, and we said that, you know, I mean, obviously there's been a bounce because obviously the, you know, stamp duty and so forth, and the interest rates, and there's more buy-to-let lenders come back in the market. But you know, you'll see after summer, but you know, until after in November, you'll start seeing a true reflection of how things are going. But demand is still strong for rented property, obviously. People, as I said, people still need to sleep somewhere.
Yeah, absolutely. And just going back to what you said about the removal of Section 21, we obviously know that's coming in at some point. I've been speaking to landlords more and more about maybe them moving away from Section 21 now to get used to it, and using Ground 1 a little bit more, because obviously that's, if they've lived in the property, then it's doable. If they haven't, then it's not. But also, we were expecting these big pre-action protocols to come in. Obviously, we've got a very robust one for the social sector, but we were expecting that to come in for the private rented sector. But is this it now? Is this amendment to the practice direction it, or is there more protocols coming?
There will be more. The problem is that it needs legislation, so they can't bring it in. So the emergency quick fix about the courts and dealing with it, because the whole point of this reactivation, everything that's come in, is to deal with backlogs. That's the whole point, and that's why it's come in. Pre-action protocol will come in. I mean, Tim in my office, who's our legal director at Landlord Action and for the property redress scheme, he's advising the government on the pre-action protocol. So that is going to come in. Mediation. I'm part of a group called the Lettings Industry Council, and we commissioned a report called Beyond Section 21. It's a really detailed report. All the stakeholders and Landlord Action, we contributed to it. We had law graduates put together, had them in the office. They've been working, and we haven't released it yet because we don't want it to get lost in everything that's happening. It's been sent to MPs, and it's called the unintended consequence of banning Section 21, about the issues that may happen. Ground 1 under Section 8, very, very difficult. What will happen is the 17 grounds of Section 8 will go up to 21, 22 grounds, and they need to make more mandatory. The problem you've got is that we were doing a whole load of work on that. COVID-19 thrown everything up. The game has changed. The ball, you know, it's completely changed. So thankfully, as you know, there was over 20,000 replies and consultations, and you know, I think the good thing is they didn't try and speed it through and bring the ban in through the back door, because as I've said, I even said it last night, the banning of Section 21, you know, and I remember issuing claims when the accelerated procedure came in that year. Right? I know about it, and obviously I know about it because I helped draft Section, you know, the 6A, and I gave evidence on retaliation eviction. You've got to realise in 2015 there was 35,000 accelerated claims. Last year there was 20,000. There's loads of barriers. It's been going. you know, but most landlords were using it for rent arrears. Okay, so now they're going to use a Section 8. The biggest problem that you have, and this is where the government didn't understand, is that the banning of Section 21 will create more homelessness, because you're going to have vulnerable tenants that can't get through referencing. You've got a problem with antisocial behaviour, so they've got to loosen those grounds up, because tenants don't like other co-tenants and neighbours don't like giving evidence because they're scared and intimidated. And then, of course, the biggest issue, and you'll know this from working with the councils, is councils are still blatantly telling tenants to stay put so they can be rehoused for the council, okay, and wait to eviction. If you can't use, and that, with that Section 21 order, and the government didn't know this, and Sean, who's listening to this, he was sitting around the table when I mentioned it. The government didn't realise this at the time, but you have a tenant that gets evicted under Section 21, but there's rent arrears. They go with the Section 21, they wait for the eviction date, they wait for the bailiff warrant, they go to the council, can you rehouse me? They go into an emergency temporary accommodation, which of course is a mess as it is anyway. And then, depending on the point scoring situation, they'll be rehoused. If you get rid of the Section 21, and we did a survey, we reckon there was 56% of landlords use Section 21 for rent arrears, which is incredibly high. If they now switch to Section 8, so all of a sudden they have to go for rent arrears because most landlords write it off. Then there's all these court orders, extra court orders under Section 8 for rent arrears. The tenant is being evicted. He goes to the council, and the council someone and say, hold on a second, you owe £6,000 rent arrears. You've made yourself homeless. We can't house you. Yeah. So what happens to those tenants? No one's thought about that.
No, exactly. It's going to have a huge impact on the Homeless Reduction Act, which obviously has only just been rewritten from the Homeless Code of Guidance that we previously had, which was a bit like War and Peace, but obviously the new Homeless Code of Guidance is a lot smaller, but it constantly refers to the Section 21. Now, one of the good things about Section 21 is the fact it's a no-fault notice. So realistically, the tenant has done nothing wrong for the landlord to get their property back. And as you say, a lot of landlords do use the Section 21 because of a fault, because of rent arrears, but it's just a quicker process. So the councils recognise that no fault notice and cannot say that the tenant is intentionally homeless. However, without a Section 21, there now has to be a fault unless they really change the structure of how the Section 21, the Section 8 grounds are going to work. There are going to be more and more people that are going to be found intentionally homeless, and the councils aren't going to owe them a duty.
Correct. And people, they just haven't got it. That's the reality. It's an issue. And the amount of landlords that have said, my tenant has encouraged me to serve a Section 21, that's why I have to do it. That's why I have to pay the legal fees. And they obviously never, ever get the legal fees back. It's an issue. And the Section 21, the banning of Section 21, and let's think about it. Section 21, ASTs came in 1988, so there was movement in the market. Landlords knew they could get their property back. They could sell it, they could whatever. It's an issue. So that's why it can't be rushed. And that's why you've got to make sure that you've got the mechanisms in place to actually say, right, you can do this, you can do that. You can get your property back within a timely period. The problem now is COVID-19 is a test to all of that with the court system.
Absolutely. Sean, you've got your hand up. Have you got a question for us?
Yeah, no, hello everybody. I am listening, Paul, and it's very interesting what you're saying, and I'm learning a lot myself actually. So I'm Sean Hooker, head of property redress scheme. Paul, you mentioned earlier on about the the importance of mediation. Why should a landlord engage with a professional mediator rather than there's a lot of kind of free forms and everything for doing rent agreements and other stuff there, but what's the benefit of using mediation over trying to do it yourself?
So you know what, everyone forgets, especially a lot of landlords, that they're the most guilty in all this. I know Nick doesn't forget because Nick's been a seasoned pro landlord for years, but this is a business, okay? And actually we are in the midst of an emergency, which means that, as I've quite rightly just said, and Julie's agreed with me, it's going to take you a year to get your property back, give or take. From a 3-month notice period, and then 7 months down the line to get, or 10 months or whatever, to get your property back. If you can engage with your tenant and do a payment plan, because everyone falls in hard times, right? Whatever it may be, everyone doing your life plan falls in a hard time. If you can work with your tenant, they can pay it off over a reasonable amount of time. Makes sense. Keep them in your property. You know they've been a good tenant, okay? Obviously, there's numerous different reasons and loads of complaints. That's a different story. The biggest problem is just trying to get tenants to engage. And as I've mentioned, Sean, and you'll know this from the stats, us at the property redress scheme, we've settled 50% of our cases, which means you've done a payment plan, or you've been able to work the tenant to leave the property early, and you can get them to sign a deed of surrender. And I think we charge all in about £500 for 3 steps, and our mediators are trained mediators. You know, landlords try and do the mediation yourself, but the thing is, a landlord and a tenant, the relationship is fractious. Trying to get a tenant to speak on the phone is a different scenario. Speaking to a mediator, knowing it's impartial, might be a lot easier to engage with both parties. Obviously, with a tenant, even, you know, a tenant's relationship with a letting agent, that can be fractious. Okay, so mediation is going to be at the forefront of the government's new rules with regard to court cases and housing courts and all that type of stuff going forward. And it's going to be now, I think the legislation is going to be rushed through to now be part of a process where you have to, like we're doing the reactivation notice, well, what you need to do is you need to find out if your tenant's vulnerable. Can they speak English? Can they read the tenancy agreement? Do they need to apply for universal credit? Do they have mental health issues? What's the plan? And you need to show this, because you'll need to do a tick box on your claim form to be able to do it. Whether, if you don't do it and you can't get the possession order because you didn't engage in it, that's one story, we don't know yet. Or whether you just can't, you won't be allowed to get your costs at court because you didn't do that. But obviously the mediation pre-action protocol will come in place if there is a rent arrears owing in the private rental sector, just like it is in the social housing sector. I don't know, Julie, if you've got anything to add to that.
No, I mean, I totally agree, and you've said everything that I would have said anyway, and I think that for the private rented sector, it will probably mirror to a degree what's already in place for the pre-action protocol for social landlords. I think it will put an onus on the landlord to have to basically be a benefits advisor for their tenants, as it does for the social landlords, obviously ensuring that tenants have applied for all the benefits that they should be entitled to, etc. But again, how do you police that, and how do you support landlords to do that? Obviously, people that work in social housing are trained in the job that they do. Nobody is training landlords how to be this new breed of landlord that we're wanting. You know, we're expecting landlords to be immigration officers because they have to make sure they do the right to rent checks under Section 22 of the Immigration Act. You know, we're expecting them to do so much, but we're then taking away as well. You know, we're taking away their ability to claim on their taxes. We're taking away so much from them with Section 24, but then we're just putting more and more pressure on landlords. I wonder whether there is an ulterior motive here to make us a little bit more like the rest of Europe, where you don't have individual landlords in France, Germany,
Well, no,
Spain.
the government, listen,
corporations.
It's quite clear, Julie. The government don't have the appetite, and we know this, and Sean will agree with this as well from speaking. We regularly speak to government. You know, generally, they don't have the appetite for small landlords, small little business landlords, whatever. This is a business. You've got to be professional. You've got to look at it as professional. There's more and more hurdles. They love institutional investment. They really want a lot more build to rent investment. And you know, you know, we think that there's a lot now. I mean, if you look at countries like Sweden and Germany and whatever, there's so much regulation like you would not believe. But down the track, what's happening? Landlords will be part of a redress scheme. That's a given. I'm pretty sure that's going to happen. You've got letting agents that now obviously will have to have ROPA, which Sean's involved in, which is regulation of property agents, which is a good thing. You know, and we do a lot of letting agent training at Hamilton Fraser. And then, of course, the final step will be all landlords will have to be registered. Exactly like what's happened with Rent Smart Wales in Wales and in Scotland. And you know what? You know, and I remember one comment. Sean was on a panel with me at the Landlord Investment Show, and he's totally right. You know what? A lot of landlords, and Nick's been a landlord for many, many years. And I remember he came to my office just after I set up Landlord Action 15, 20 years ago, whatever. The game has changed. Totally has utterly changed. And if you can't adapt with it, okay, but don't get demand strong. People need to sleep somewhere. Rents are going up, this, that, whatever. You know, if you don't want to change with it, well, then you've got two options. You get an agent to totally and utterly fully manage for you. So you don't have any interaction with your tenant. Or you sell, you get out, which is what Sean says. You know, it's no point moaning and bitching because it's happening. The game has changed, you know, and you have to move with it. You've got a commodity, which is a property, and you can get an income. And if you don't like it, there's your two options.
Yeah, exactly. And we've just had a comment coming from Maria in the chat. She says the problem with that attitude is that there will always be the small landlords that fly under the radar, and there are not enough policing of the regulations.
Yeah, agree.
So I agree with that totally.
I unfortunately I have to go. I've got another video call I've got to do.
No, that's fine, Paul.
I apologise for having to up and leave you, and but it's been a pleasure, everyone, and thank you for joining. And Julie, thank you for having me on.
No problem. Thanks very much, Paul.
Take care. All the best, everyone.
Oh, thanks a lot, buddy. Have a nice day, sir.
Keep well. Keep safe, everyone. Bye-bye.
Cheers.
Bye.
Thanks.
Great. So does anybody else have any more questions? If not, then I'll bring the meeting to a close. And just to let you know, this is, like I say, it's being recorded and it will be uploaded onto our YouTube channel. So if there's anything that you missed, or if you want to see those slides again, it will be on the YouTube channel available for you. So if there's nothing more from anybody else.
Could you send your link out to this that everybody's attended it, just so we can see the video again, and your YouTube video we can see, because there's so much information. I'm going to probably watch about 19 times.
No problem at all.
So
all the attendees will get a copy of the slides and a copy of the recording as well.
And Julie, can I say thank you for setting this up. Sincerely, I've been waiting for this. This is the first time I've been up before 11 o'clock in about 19 weeks. So thank you very much.
That's all right. You can go back to bed now.
I really appreciate you setting this up. So thank you, my flower. Thank you very much.
No problem. Thanks very much, everybody. And I will, obviously, as soon as we get updates, I'll be posting those as well. So thanks very much, everyone, for joining today. And I hope to see you at the next event.